Assalamualaikum warahmatullahi wabarakatuh. My name is Mardhiyyah binti Aziz Nordin, metric number 051741 from group 13, class B. So today I would like to present about Child Pornography Act 2021. So in this act we have 5 parts, which is the first part is preliminary, part 2 offences relating to child pornography, part 3 person in a relating of trust, part 4 protection of children against sexual abuse and exploitation on cyber, and the last part is for the punishment of child pornography offences in Malaysia. So part 1 of this act contains 2 sections, which is section 1 is short title and section 2 is interpretation, which in section 2 have 2 subsection. In subsection 1 stated that this act applies to children under the age of 18 or the age of majority, and while this act relates to any other written law, it applies to children of the age specified in that written law. While in subsection 2, it defines few words that was included in this act as the main subject matter. So the interpretation part is concluded in this act on the basis of the study of jurisprudence, helps to put law in its proper context by considering the needs of the society and by taking note of the advances in related and relevant disciplines. Then part 2 is regarding the offences relating to child pornography, which contain 4 sections, which is section 1 child pornography, section 4 using or inclusion of a child in any part of the production of pornography, section 5 producing, distributing, advertising child pornography. So this section covers both principle of Western and Islamic jurisprudence. It was stated that in subsection A, any types of sales to produce money from the production of child pornography is an offence and forbidden under the Islamic law. So the following subsection provide that it is an offence to advertise, make exchanges, publish, prints, or participate in making profits when he or she knows such business in related to child pornography production. So in section 6, regarding the having possession or accessing pornography involving the underage child. So according to the main source of Sharia law, which is the Quran, it was stated in Surah Al-A'raf verse 33, which apply that watching pornography or other indecent acts in the privacy of the home or on the internet is forbidden. Same goes to the term of lower the gaze in section 6 clause 2 is according to a Quran verse. So in Surah An-Nur verse 30 until 31, it means that the men must restrain their gaze and guard their private parts. Surely Allah is well aware of all what they do and enjoin believing women to also restrain their gaze and guard their private part. For part 3 of the Act is person in a relationship of trust. So it contains 1 section, which section 7, person in a relationship of trust. So by referring to the sociological school, this is to protect the interests of the society and of individuals by coordinating those interests to minimize the possibility of social conflicts. So this application is to ensure fair distribution of social benefits and burden among the members of the community. Thus, sociology is defined as a branch of the science of human behavior that seeks to discover the causes and effects that arise in social relations among persons and in the intercommunication and interaction among persons and groups. While part 4 of the Act is regarding the protection of children against sexual abuse and exploitation on cyber. So for part 4 of the Act contain 2 sections, which is section 8, protection of victim in court proceeding. So while drafting this particular section 8 for part 4, Western jurisprudence principles are applied because section 8 is included in this Act as it is essential to look into the well-being and mental state of child during proceeding. This is due to the fact that sometimes trial of a case may go in a rough phase, and that can impact a child's mentality badly. While for Section 9, regarding the criminal liability of child involved in pornography. So the principle underlying in this provision is the Western jurisprudence, which a child under the age of 18 is unable to comprehend the situation and the effect of their action, especially when it involves pornography. So as minors, they do not possess the capability to distinguish evil from good, and thus it is for the law to protect the interests of children. So for the last part of the Act, regarding the punishment. So under last part of this Act contain 3 sections, which is Section 10 regarding the failure to give information, Section 11 provision regarding whipping, and Section 12 punishment of child pornography under ta'zim. So this provision applied the concept of Said al-Zara'i and Qiyas, which technically means blocking the permissible acts which lead to an evil. Therefore, since the offense of a child pornography did not have any specified punishment in the Quran, so traditionally ta'zir punishment can be applied. Since in Islamic law, ta'zir refers to punishment, usual corporal, that can be administered at the discretion of the judge as opposed to the hudud. For Qiyas, it emerged during the time of Al-Shafi'i, and consequently, it helps to encounter any legal issue raised, and it was gradually accepted as the fourth source of law in Islamic country. So, in regards to the punishment under this Act, it can be seen that this harsh punishment must be imposed against those who were involved in the child pornography offences, since the act of sexual harassment itself already prohibited in Islam. In addition, the very nature of a ta'zir punishment is that the punishment is not fixed, and it is up to the qadi or judge to impose something that will be sufficient as a deterrent while suiting the gravity of the crime. Thus, in realist school of thought, they emphasize more upon what the courts may do rather than abstract logical deductions from general rules of legal system. So that's all for the individual presentation of Child Pornography Act 2021. Thank you.